Types of partners. A partnership firm can have different types of partners with different roles and liabilities. These are described as follows. Number one, active partner. An active partner is one who contributes capital and plays an active role in managing the daily functions of the business. The active partner is also known as ostensible partner or managing partner. Sometimes he draws remuneration as salary for his hard work. He has unlimited liability. He shares profit and loss of the firm. Number two, sleeping or dormant partner. Partner who only contributes capital to the firm and does not take part in the day-to-day activities of the business is called sleeping partner. A sleeping partner, however, shares its profit and losses and has unlimited liability. Third, partner by estoppel. If a person through his or her own initiative, conduct or behavior gives an impression to others that he or she is a partner of the firm, he or she is called partner by estoppel. He does not take part in its management. He does not contribute capital. He does not share profit and loss. His liability is unlimited as in the eyes of the third party. He is a partner of the firm. Fourth, Ria is Ayla's friend. Ayla is a partner in a software firm, ABC Solutions. On Ayla's request, Ria accompanies her to a business meeting with simple softwares and actively participates in the negotiation process for a business deal and gives the impression that she is also a partner in ABC Solutions. If credit is extended to ABC Solutions on the basis of these negotiations, Ria would also be liable for repayment of such debt as if she is a partner of the firm. Fourth, secret partner. A secret partner is actually a partner of the firm, but his association with the firm is unknown to the general public. He contributes to the capital of the firm, takes part in the management, but secretly shares its profits and losses and has unlimited liability towards the creditors. For example, if there is a press conference by the firm, he will not come on the dais of the partners. Fifth, nominal partner. A nominal partner is one who allows the use of his or her name by a firm and normally he gets a fees from the firm. These nominal partners are the most well known individuals, businessmen, celebrities, etc., who allow their names to be added to the company to increase its goodwill. He does not contribute to its capital. He does not share its profit or losses. He does not take part in company's management affairs. His liability is unlimited. 6. Partner by holding out. A partner by holding out is a person who is not a partner in a firm but knowingly allows his name to be represented as a partner in a firm. His liability is unlimited. In case he is not really a partner and wants to save himself from such a liability, he should immediately issue a denial clarifying his position that he is not a partner in the firm. If he does not do so, he will be responsible to the third party for any such debt. He does not bring any capital. He does not share profit and loss. He does not participate in day-to-day functions of the firm. Under a partnership structure, you are jointly and individually responsible for the debts of your business partners. This means if one of your business partners are unable to pay a debt that they have incurred on behalf of the business, you may need to pay this debt yourself.
Now, would we understand the difference between different types of partners in the shape of a table? First of all is active partner. Active partner contributes to the capital of the firm. He participates in the management, daily management of the firm. He has his share in the profits and losses of the firm. Active partner has unlimited liability. In case of sleeping partner or dormant partner, it does not mean that he sleeps in his life always. It means that he does not care on what is going on in the organization. He does not, he contributes capital to the firm, but he does not participate in the day-to-day functions or the management of the company. However, he shares the profits and losses of the firm. He has unlimited liability. In the case of secret partner, though he is a partner in the firm and he contributes capital to the firm, but he secretly participates in the management functions of the firm. He has his share in the profits and losses of the firm and he has unlimited liability. Nominal partner, as already told, is normally a celebrity or a known person in the relevant field, in any field. He does not contribute any capital to the firm. He does not participate in the management of the firm. Generally, he does not share profit and losses of the firm. He has unlimited liability. Partner by estoppel does not contribute capital to the firm, nor he participates in the management of the firm. He also does not share profit and losses. He has unlimited liability. Partner by holding out also does not contribute capital. He does not participate in management and he also does not share in the profit and losses of the firm. He has unlimited liability. Now we will understand what is whether minor can be a partner in a firm. Partnership is based on a legal contract between two persons who agree to share the profits or losses of the business carried on by them. A minor is incompetent to enter into a valid contract with others because he is a minor, because he has not attained the age of maturity. So he cannot become a partner in any firm. However, a minor can be admitted to the benefits of a partnership firm with mutual consent of all the partners. In such cases, his liability will be limited to the extent of the capital contributed by him in the firm. He will not be eligible to take an active part in the management of the firm. He can share only the profits. However, if there are losses in the firm, the minor cannot be asked to bear the losses. However, a minor can inspect the accounts of the firm. As a minor becomes major, so far as the age is concerned, his status changes. In fact, on attaining majority in age, the minor has to decide whether he would like to be continue to be the partner of the firm or would like to resign from the partnership of the firm. He has to give a public notice of his decision within 6 months of attaining majority. If he fails to do so within the stipulated time, he will be treated as a full-fledged partner. That is, if he does not want to become the partner or attaining the majority, he has to give a notice, public notice, that he does not want to continue to be the partner in the firm. But if he does not give such public notice within 6 months of attaining majority, then he will be treated as full-fledged partner and he will have unlimited liability in the same way as other active partners face the liability. So we can say that a partnership firm cannot be formed with a minor as the only other member.
Now we will discuss the types of partnership. partnership can be divided on the basis of duration as well as on the basis of liability. On the basis of duration, partnership is of two types: partnership at will and second is particular partnership. On the basis of liability, partnership can be divided into general partnership and limited partnership. Now we will discuss the classification of partnership on the basis of duration. Number 1, partnership at will. This type of partnership remains in existence at the will of the partners. In this type of partnership, there is no definite condition indicating how long the partnership will exist. It can continue as long as the partners want. Any partner may terminate a partnership at any time by giving a notice of withdrawal from partnership. Number 2, particular partnership. This type of partnership is created just to carry out one project or to finish one task, say construction of a building or road. It dissolves automatically when the purpose for which it was formed is fulfilled. Now, our topic is classification of partnership on the basis of liability. Number 1, general partnership. In general partnership, the liability of partners is unlimited and joint. This means that the personal assets of the partners can be seized to settle debt obligations or lawsuits. Further, any partner may be sued for the business's debts. All the partners have the right to participate in the management of the firm, and their acts are binding on each other as well as on the firm. General partnerships are easy to dissolve. The business is dissolved if any of the partners declares bankruptcy or passes away. Registration of the firm is optional. Second, limited partnership. In limited partnership, there is at least one general partner who manages business and takes on unlimited liability. The remaining partners are limited partners who hold financial stakes in the business. They have limited liability. Limited partners cannot be held personally liable for the debts of the business as they do not actively manage it. Registration of such partnership is compulsory. Such a partnership does not get terminated with the death, lunacy, or insolvency of the limited partners. Limited partnership was not permitted in India earlier. The permission to form such partnership has been granted in 1991 so that small scale entrepreneurs may attract equity capital from friends and relatives who were earlier reluctant to help due to existence of unlimited liability clause in the partnership form of business. Limited liability partnerships are an extension of a GP. GP here stands for General Partnership. A limited liability partnership is a form of partnership where the partners have limited liability. Partners share risk and profit based on their investments in the business. LLP combines the flexibility of a general partnership with the limited liability of a company. In this form of partnership, no partner is responsible or liable for the misconduct or negligence of other partners. One big advantage of limited liability partnership is that the partners are not personally liable and cannot be forced to pay a business debt or liability with personal property or assets. In India, Limited Liability Partnership Act 2008 is broadly based on UK LLP Act 2000 and Singapore LLP Act 2005. In some countries, LLP must also have at least one general partner with unlimited liability. In US, some states restrict this form of partnership to certain professions such as lawyers, doctors, accountants. Registration of a partnership firm. Registration of a partnership firm means the entering of the firm's name along with the relevant prescribed particulars in the register of firms kept with the registrar of firms. It provides unquestionable proof of the existence of a partnership firm. In India, registration of a partnership firm is not mandatory under law. It is optional. In case a firm does not get registered, it is deprived of many benefits. The consequences of non-registration of a firm are as follows. A partner of an unregistered firm cannot file a suit against the firm or other partners. B. Unregistered partnership firm cannot file a suit against third parties. And C. The firm cannot file a case against the partners. Keeping in view the adverse consequences of non-registration of partnership firm, it is advisable to get the firm registered. According to the India Partnership Act 1932, the partners may get the firm registered with the registrar of firms of the state in which the firm is situated. The registration can be at the time of formation or at any time during its existence. Procedure to get the firm registered. The procedure to get the firm registered is as follows. Number one, submit an application on the prescribed format to the registrar of firms. The application contains the following particulars: name and location of firm, name and addresses of the partners, date when each partner joined the firm, duration of partnership. Application should be signed by all the partners. Some documents like PAN cards, address proofs of all the partners, and partnership deed have also to be submitted. Number two, deposit of required fees with the registrar of firms. Third, registrar after thorough examination of the documents will issue a certificate of registration. Thanks for watching. If you like our course, please spare some time to give a star rating to our course.